Welcome to this week's edition of Florida Appeals Journal. I'm Jennifer Carroll, and as you know, each week we try to visit issues and or cases of significance to practitioners at both the trial and appellate levels. So let's take a look this week at how do you respond to affirmative defenses at the trial level. That's a very significant issue and really one of the most misunderstood issues among litigators. Let me read you the rule, and I'm sure everybody knows it, but let's just take a look at it. It's Florida Rule of Civil Procedure 1.140B. It talks about the defenses. A complaint's been filed. There's going to be an answer, affirmative defenses. So how presented? Every defense in law or fact to a claim for relief in a pleading must be asserted in the responsive pleading if one is required. But the following defenses may be made by motion at the option of the pleader: so lack of jurisdiction over subject matter, lack of jurisdiction over the person; 3, improper venue; 4, insufficiency of process; 5, insufficiency of service of process; 6, failure to state a cause of action; and 7, failure to join indispensable parties. So a motion making any of these defenses must be made before the pleading if a further pleading is permitted. So, for example, a motion to dismiss for failure to state a cause of action. All right. And then it enumerates the grounds on which any of these defenses are based, need to be stated specifically and with particularity in the responsive pleading or motion. And then it continues to proceed with that. Now, I also refer you to Rule 1.100A, and that governs the reply. In the reply, you have an answer, affirmative defenses. The reply is laid out in 1.100A, and that makes the filing of a reply to an answer mandatory if the answer contains an affirmative defense that the opposing party seeks to avoid. And of all the pleadings, it is the reply to an answer that's probably the most misunderstood. And it's very typical practice among litigators. Filing a reply to an answer that merely denies the allegations of the affirmative defenses is widespread. And it's often viewed this is really surplusage. Allegations to which no responsive pleading is required are deemed a denial under Rule 1.110E. So it's really not necessary to file a reply to an answer merely to deny the allegations of an affirmative defense. And I'll cite you to a traditional case, the Equibank case, 344 Southern 2nd 629, and that's First DCA 1977. But a reply is required only if the pleader wishes to avoid, as opposed to denial, but to avoid an affirmative defense. So in other words, to plead some new matter to prevent the effectiveness of the affirmative defense. And failure to plead avoidance to an affirmative defense can be corrected by presenting evidence without objection at trial on the issue. And that basically has the effect of amending the pleadings to correct that deficiency. But remember, keep in mind, there is a difference between a denial and an avoidance. Okay. Now, what do you do with your affirmative defenses? If you're the plaintiff, the defendant has filed an answer in affirmative defenses. What if you've got defenses that are insufficient as a matter of law? Or let's say you've got defenses that lay out allegations that are just pulled from thin air, and they're scandalous, impertinent, immaterial, irrelevant. You want to go by the motion to strike rule, and that's of 1.140. And you want to move to strike, of course, before any reply would be due. So you can't just let parties get away, the opposing party just get away with putting anything they want. It's all different strategy a lot of litigants will think, well, they can plead general, but hey, they haven't made the elements here. So I'm going to come back later and try to do summary judgment. And that way I can argue to the judge, well, not only is there no evidence, but they haven't even pled it correctly. But you have to be careful. It seems like years ago that was the normal course. But you have a lot of, and I think a lot of judges will accuse you of, oh, you're just trying to set up and play gotcha. I disagree with that rationale, but there is that line of thought there. So as a general practice, you do want to, and often it does depend on the type of case, of course, but you do want to force, if you've got boilerplate defenses, the opposing counsel is just throwing anything in there, really doesn't have any support. A lot of times you are going to have to get them to really define their terms. Now we know with many defenses, such as fraud, for example, that's the most common, you have to plead those with particularity because that's often abused, and you can throw in so many ridiculous allegations, but they're prejudicial. They're designed to taint the court. So you really want to force them to comply with the rule of specificity. So you really need to know the causes of action, do your research, know the elements of the defenses that are raised in the affirmative defense, and then you can move to strike. Strike those, and in the alternative, you can also move for a more definite statement. And you're going to use the motion for more definite statement, and the exact rule number on that is 1.140E. But that's when you've got if a pleading to which a responsive pleading is permitted, it's a general rule. If it's so vague and ambiguous that you can't really expect the other party to be able to frame a response or an answer or any kind of reply to it, then you've got to go ahead and you can file a motion for a more definite statement. But in your motion, you have to be pretty specific. You've got to point out what are the defects you're complaining of and what's the information that you're seeking. And that's all just a matter of fair play, and I think judges will understand that. So it's a good practice to go ahead and do that. And you can do a motion to strike on the one hand, and then in the alternative, do a motion for more definite statement. And in the motion to strike, again, if it's clearly insufficiency of the pleading, that no, you're really not following the law here, you can't even allege the elements here, even your affirmative defense, you do want to move to strike it as being insufficient as a matter of law. And certainly if you've got scandalous, outrageous allegations, which unfortunately that happens all too often in today's litigation world, then you do want to go ahead and move to strike it. So the bottom line is you've got many tools in your arsenal, but it's knowing what's really going to be the best approach. So for your courtroom savvy recommendation, definitely for this week, is when you are looking at the pleadings, look at them very carefully. And of course, you'll know the rules and you know the deadlines, but you want to, especially when dealing with affirmative defenses, you want to look carefully at them and don't let your opponent get away with just doing loose, general boilerplate. Again, it does depend on the circumstances of your case, but generally you do want to go ahead and certainly get rid of it as being insufficient as a matter of law if you have that. And otherwise, if it is so vague that you can't really properly know what the heck your defense of that affirmative defense is going to be, then you need to force their hand and force them to detail with specificity, with a certain amount of specificity, what they're talking about in compliance, again, with Florida Rule of Civil Procedure 1.140. That's the issue for this week. Keep us posted on any issues that you want to be heard, that you would like to have heard on our weekly Appeals Journal segment. Thank you. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.